Hi, this is Kelsey Fukowski, and in this video we're going to be looking at the landmark Supreme Court case known as Marbury v. Madison in 1803, which is arguably the landmark court case that defines the Supreme Court and its power of judicial review today. So let's get right into it. To understand this case, you have to go down to the background of the election of 1800, and the Federalist John Adams is going to be defeated in the election of 1800 by the Democratic Republican Jefferson. And what the Federalist, John Adams, is going to do right before his term expires is he's going to make a number of last-minute appointments to the judiciary known as midnight judges, because it's literally right at the final hour of his presidency. And after these appointments are made, Jefferson is, of course, going to try to prevent the Federalist appointees to the judiciary, right? He doesn't want a Democratic Republican appointed, and he's not going to see it as legitimate. Well, William Marbury is one of these midnight judges appointed by, of course, this Federalist John Adams, and the Secretary of State under this Democratic Republican, Thomas Jefferson, is going to ignore the writ of mandamus to deliver the commission, which again would legitimize his appointment to the D.C. judiciary. So Marbury, being upset that his commission was not delivered, is going to ask the Supreme Court to force Madison to deliver it. Don't get too bogged down in these details, as it's really the decision that's ultimately going to be most important. So from Marbury's point of view, James Madison, as the Secretary of State under Thomas Jefferson, even though he is a Democratic Republican, is required to issue this writ of mandamus, as the appointment, from his point of view, is legal. You also had a piece of legislation passed by Congress known as the Judiciary Act of 1789 that does empower the Supreme Court to adhere to Marbury's wishes. And keep in mind, the Supreme Court in our country is relatively young, and there's no precedent that says, well, the Supreme Court can't do this. So everything from Marbury's point of view is the court should certainly order Madison to deliver his commission. From Madison's point of view, he's going to say, well, this appointment is illegitimate because his commission was not delivered before Adams left office. This was a midnight appointment. And even more, he's going to make the case that this is a political case, not one that can be settled by law. And that's a very astute point by Madison, and that's certainly something that the Supreme Court really wants to avoid, are political cases, as political issues should be settled by Congress. But nevertheless, if you had to take a guess and not knowing anything about this particular case, you would probably think that if the Supreme Court had a Chief Justice who is a Federalist, that this would go the way of Marbury. Well, not so fast. So John Marshall is our Federalist Chief Justice of the Supreme Court, but he sort of sees the bigger picture here. Yes, Marbury is a Federalist and he would support him, but he's looking again at the bigger picture here. He's worried about the legitimacy of the Supreme Court, because remember, the Supreme Court lacks the power of implementation. They can make any ruling that they want. However, they have no power to enforce it. So with a Federalist Supreme Court and a president who is Democratic Republican, he wants to make sure that the Supreme Court is listened to. So why not make a decision that's tailored to Jefferson's point of view while the Supreme Court can get something out of it? So unanimously, the Supreme Court is going to rule that they did not have the power to order Madison to deliver the commission. And they go one step further by striking down the Judiciary Act of 1789 that originally allowed the Supreme Court to essentially, force Madison to deliver the commission. But of course, Marshall is going to argue it violates Article 3 of the Constitution, as this did not fall under original jurisdiction. Because if you look under original jurisdiction in the power of the Supreme Court, it has to involve ambassadors, public ministers, consuls, states, etc. And this did not fall under one of these important topics. So, of course, while Marshall was certainly a supporter of Marbury getting this appointment, this was undoubtedly a prime opportunity for SCOTUS to give itself a power. It did not have the power that it utilizes today, known as judicial review, which allows it to declare a law unconstitutional. Again, the original Constitution, if you look in Article 3, the Supreme Court does not have that power. The fact that the Supreme Court got this power of judicial review significantly strengthened it, and it put it arguably on equal footing with the legislative and the executive branch. So John Marshall is, very smart in seeing the big picture here, as, of course, Jefferson's not going to disagree with the ruling. Of course, he might disagree with the idea of judicial review, but of course, Jefferson's going to adhere to this. And so simply, the Supreme Court essentially just gave themselves this power and nobody challenged it. It was a genius move. And this is what gives the Supreme Court its power today to declare all types of laws that it does see unconstitutional. So again, the big idea here, judicial review, puts the Supreme Court on equal footing with the other two branches. And that, of course, is going to be the superpower of the Supreme Court. And Marshall is going to do this as a result of Marbury v. Madison.